Should be good to go.
All right. Well, good morning, everyone. It's 10:02, and I'm going to call the February 13th, 2026 meeting of the Task Force on Mandatory Minimum Sentences to order. Don, if you could take the roll, please.
Absolutely. Shane Baker.
Here.
Shane Baker is here. Jeremiah Carlson. Jeremiah Carlson is not here. John Donovan.
Here.
John Donovan is here. Dale Harris.
Here.
Dale Harris is here. Amber Johnson. Johnson is not here. Morgan Kuntz.
Present.
Morgan Kuntz is here. Kelly Mitchell.
Here.
Kelly Mitchell is here. Mark Osler.
I see him here, but he's an attendee.
What was that?
Needs to be elevated.
Oh, he needs to be elevated? Okay. Give me a second.
I think Jeremiah Carlson as well.
I do not see him in the attendee list.
It's over there on the right screen.
Oh.
Oh yeah, he's. Okay, Mark
I'm
Osler.
here. I'm here.
Excellent. Nate Wright,
Present.
Ken Sass,
Here.
Ken Sass is here. Nick Sasser,
I'm here.
Nick Sasser is here. Robert Stewart,
Here.
Robert Stewart is here. Ashley Stewart Griffith,
Here.
Ashley is here. Jeremiah Carlson, can you hear us? I see him online, but not sure, but we do have a quorum.
It is possible to unmute somebody. Maybe he's having trouble unmuting himself. I don't
Give
know.
me a second and I can give that a try. So, Jeremiah, can you hear us?
He had broken up a little bit in our last meeting, so he might be having a connection issue.
Okay.
All right. The next item on the agenda is approval of the January 2026 minutes. Oh yeah, I'm going to use the Robert's Rules of Order trick and ask if there are any corrections to the January 2026 minutes. Are there any corrections to the January 2026 minutes? Hearing none, the January 2026 minutes will stand adopted as prepared. And then to the agenda, any additions or corrections to today's agenda? And I guess we'll just go with that agenda. But again, looking at Robert's Rules of Order, if you adopt it, then you're really stuck with it. It's kind of a rigid thing. So we'll just follow it informally rather than formally adopting it. All right. So sort of a you are here moment from my perspective. We've gotten a lot of information about some of these mandatory minimums, and it's like, think of us. So speaking as somebody who's for some reason on his third cold of 2026, I have no idea what's going on with my immune system. But as part of that, I've had 2 visits to the emergency, or not the emergency, or the urgent care, and so I'm maybe thinking in medical terms a little bit more than normal. But so what we've done so far is we've gathered a lot of information on the patient, and what our task is to sort of prescribe a treatment program for the patient, assuming there's something wrong. And where we're at right now is kind of the middle stage there of diagnosis. So what I'd like to do today, and I think it's pretty ambitious, is to essentially come up with a diagnostic, some kind of a diagnostic analysis, particularly about the big two. Again, there's many ways to slice this up, but I'm the way I'm conceptualizing these mandatory minimums is I'm breaking 6 and 9/11 into 2 mandatory minimums. You could lump them all together if you wanted, just call it one mandatory minimum. You could also call it, I don't know, 5 different mandatory minimums. But I'm breaking it up as 2 mandatory minimums. On one hand, you have what people sometimes call felon in possession, the crime of possessing a firearm after you've been convicted of a so-called crime of violence. And that's a 5-year mandatory minimum waivable. And then the other is really a bunch of different mandatory minimums, but they all have to do with committing a listed offense, an offense listed in 6911 subdivision 9, with a dangerous weapon. And that can be possession, in the case of a firearm, or use in the case of another dangerous weapon. And there are different mandatory minimums depending on whether it's your first time or repeat and that sort of thing. But they all have that same basic structure, and that's also waivable sometimes, and sometimes it's not waivable. So the diagnostic criteria that we're using today, we're really borrowing heavily from Ashley Sturts Griffith's proposal. And if you see in the memo that I sent out to the chairs on January 21st, which is in your meeting materials, I really kind of adapted that. And actually, I hope I'm not taking your structure and bending it beyond its intended use. Let me share. Do I have the ability to share something?
Yes, you do.
It's like I do. Okay, so basically, what we're going to try to do today is fill up 28 squares with useful information. And these 28 squares have to do with the 2 policies. So on one hand, the mandatory minimum for possessing a firearm or ammunition after crime of violence, and then the other policy is the committing a listed offense with a dangerous weapon. And we're going to apply these 7 evaluation domains to those 2 policies, which is 28 squares. And we got a 2-hour meeting to do so. So we've got limited time here to do all of these. Yes,
Can I
ma'am.
ask a question?
Sure.
'Cause it was a matter of interpretation, so I just want to make sure that I'm understanding the second column there that talks about committing a listed offense with a dangerous weapon. I guess I interpreted that as the not firearm version of the offense, but you mean it to be both versions, like
I do.
a firearm
Yes.
or any other dangerous weapon. Okay.
Yes. Yeah, including firearm in that. And I'm sorry if that wasn't clear. Firearm is a dangerous weapon, but it's right. Like I said, you could divide that into 4, because there are 4 different, tiers of mandatory minimums that are provided in statute, depending on whether it's a firearm or a dangerous weapon other than a firearm. And but then there's a nuance there on whether it's used or not used. But and I realize these 2 are the big 2, right? I mean, we've seen the statistics that these 2 take up approximately 2/3 of the mandatory minimums that are done in Minnesota, or maybe it was more than that. And so we're trying to cover a lot of ground here. That's why we're not talking about any other mandatory minimums today, because I think we've got a pretty big slice of pie to eat just today. But yeah, and I'm sorry if that messed up your analysis. So what I've done is we have 3 committee chairs. We have 3 committees with 3 committee chairs, and I asked each of the committee chairs to grab 2 of these to kind of drive the conversation on 2 of these. And in addition to the diagnostic question of how well does it accomplish each domain. So there's again, 7 evaluation domains. How well does it accomplish each domain's implied goals? There's also another question, which is, do we need more information? We need to run some more tests on the patient, if you will. What else do we need to know to come up with a better diagnostic answer? So these 7 domains, just really quickly, are public safety. Public safety is each committee chair was asked to look at this. And I'm going to ask the vice chair to lead us through the public safety analysis. And then for each of the remaining 6 diagnostic criteria, each or evaluation domain, I should say, the each committee chair will be asked to lead us through 2 of those. So any great question, Assistant Commissioner Mitchell. Any other questions on sort of what we're trying to do today? I mean, the hope is obviously we're still gathering some information. We're going to be getting stakeholder input and so forth. So it's not like we're done gathering information, but you know, at least coming up with some preliminary diagnostic hypotheses, I guess. You know, like if you ever look at our medical chart, it'll say, you know, rule out, you know, R/O is really interesting. On a medical chart, I didn't know what it meant when I was first reading medical charts, but it's basically saying here's a hypothesis that we want to rule out. It's a preliminary diagnostic diagnosis, I guess, but hasn't reached a final diagnosis. So we're going to look at you know, diagnoses or possible diagnoses for what's how is this doing as far as reaching its goals. So hopefully our goal today is to have at least a good start on an evaluation for this. And I'm going to not share my screen during this because Wilder is going to be basically the scribe during this process, and they're going to be taking notes for us. So if there are no other questions, Jeremiah has a question. Yes.
We can't hear you,
We're not
Jeremiah.
hearing anything. Oh, now you're muted again. Well, that's unfortunate.
I'm envisioning him furiously typing out his his question.
And while they put up the 28 squares as we fill them in. Oh, I see. Put up the 28 squares, then fill in as we go. Sorry, I read that wrong. Sure.
Okay. All right. Without further ado, I'm going to pass the gavel to the vice chair, metaphorically speaking, who's going to lead us through the 4 questions applicable to public safety. I guess maybe before we begin, Ashley, do you have any comments on how we're using your evaluation criteria? Is this kind of generally what you envisioned? And I know you kind of meant it for like evaluating the policies we're proposing, but I think it's also useful for evaluating the status quo as well, right?
Yes, I think this makes a lot of sense. So I
Okay.
approve.
Oh, good. I'm happy to hear that. All right.
Yeah, thanks,
take it away,
Nate.
Morgan.
And thank you, Ashley. I had been really struggling to like get my head around this complex topic, and this metrics that you developed is just a great way. So thank you for leading on that. So yeah, when Nate asked me to lead a discussion on this, public safety, does the policy promote or undermine public safety? I was sort of just doing some thinking about like how do we usually think about public safety, and I'm sure based on my discussion with the data folks, other people maybe went in the same direction as they were thinking about their buckets here. But I was thinking about what impact do these policies have on deterrence, incapacitation, recidivism, and then just sort of generally like public trust in the system. So like the sort of things that we usually think about from a criminal justice perspective, the purposes of having criminal laws. And so I did some research just on this first box here. How well does it accomplish the domain's implied goal? And I think it's this. I think my thinking about this is really the same for both the mandatory minimum for possessing a gun and also the mandatory minimum for committing a dangerous offense, which is I haven't been able to find much research that suggests there is a deterrent effect from mandatory minimums. It seems to me that when you start looking for research on the impact of mandatory minimums on deterrent effect, most of that research suggests that there is not a large deterrent effect. And I think there's a couple reasons for that. I think one is most people don't think they're going to get caught. Especially with a gun, right? If you have a gun and you just have it in your car, you think your chances of getting caught are really, really low. And I just don't think people believe they're going to get caught. And so therefore they never think about the 5-year sentence that they might get if they do get caught. And then the other aspect of it, especially in regard to when you commit a dangerous offense with a weapon, I think a lot of these offenses, people are not thinking about the long-term consequences of their actions when they're going into an offense. And so I don't think that when people are caught up in the really intense situations that drive criminal behavior, they're thinking about the mandatory minimum that they may have. And then the last piece there is, I don't know that a lot of that people always know there is a mandatory minimum, right? And so for a mandatory minimum to sort of have an impact on the decision-making of individuals, they have to know that there is a mandatory minimum. They have to believe that they're going to get caught, and they have to commit the crime. There's some sort of intellectual exercise involved that I just don't know is happening. So from my perspective, I don't know that these policies increase a deterrent effect. But obviously others may have different views on that. So maybe we could open it up to the group and see what people think.
Can I jump in the last thing you said?
Mhm.
I was just sort of thinking in reviewing that part about people not knowing. I don't know that I'm not trial, I'm reading the transcripts. I don't know that I've ever read a transcript where someone is told you can't possess a firearm after this conviction, and there is a mandatory minimum. The firearm is sort of an automatic, but I don't know, and I don't know if your experience, you can recall a time when that's even happened, that they are telling someone.
I've seen it, it's rare.
Yeah.
There's a few judges that are very intentional about it, but most are not.
Yeah, I think first off, my mic's working now, I'm assuming.
Yep.
All right, perfect. Yeah, I think it just
Jennifer,
consider that
Jennifer,
kind
we
of that
can
thing
see
we talked
the,
about.
just sorry.
Nope, you're good. We
Okay.
kind of talked about that in our kind of our other kind of meeting when we talked about deterrence and that it is kind of a difficult stick to measure. And as we're talking about people that say, well, I got caught in the system, or I didn't believe I was going to get caught, or I was going to do whatever, those people I look to be more as not necessarily ones we're going to ever really deter, because they're already committing things. They're making the conscious decision to say, I know I'm not going to get caught in something. So for me, like, that's where the mandatory minimum really comes in, because now it's more about accountability of them, not necessarily deterrence of them. I don't think we will ever be able to create a deterrence mechanism that is going to deter all people. So that's where the accountability mechanism needs to come in play.
Mark?
Yes, thank you. It probably is a good time to interject what my committee had to say in our discussion, if we're going to the public safety part. Is that okay?
Yeah.
Okay. Yeah, there was a divergence of views. There were, there was voice within the subcommittee that, felt that it does promote public safety. It sends a message, particularly on subsequent offenses. But there was also skepticism about the deterrent effect along the lines that you were talking about, Morgan, and particularly because the affected class of people who we want to deter don't know about the enhancements. And that's something beyond for for this to be effective deterrence, it's not just knowing that you can't have a firearm, possess it, but knowing what the potential penalties are, and then making a rational cost benefit analysis based on knowledge of those penalties. And it's hard to believe that that's going on and creating public safety through deterrence. Now, there's another thing that came into the discussions too in my subcommittee that overlaps with the fairness and proportionality part, and another question as well, which is that the crimes that are listed in subdivision 9, often they're going to produce a substance that's far over the mandatory minimum anyways. And that means that in a lot of the kinds of cases where we care the most, the mandatory minimum doesn't have an effect anyways.
Yeah, good point. Any other observations on the, yeah, go ahead.
Yeah, so stakeholder input committee and a little bit of mine. The one thing that you didn't talk about as a purpose of punishment is rehabilitation. And that's where, so Ashley and I are a subcommittee of 2. So she had input on victims and I had input more from the DOC perspective, right? Some of these mandatory minimums are so short, like the year and a day for the committing a crime with a dangerous weapon that's not a firearm. Like it's so short, and now like mandatory minimum means you're sending them to prison, not jail. We can't do anything with somebody for a year. You know, like the reality is they're gonna get, you know, time served, so it's even less than a year by the time they get to us. We have to process them, we have to get them in the queue for all the things that we have. We don't have enough treatment to go around as it is. So the reality is like they're probably just gonna sit there for that year. And we know there's also countervailing research that says that prison can be a criminogenic, increasing environment. So it could actually make you worse. So is that effective for those really short mandatory minimums? I would say no. For the people who are committing more serious crimes where there might be a longer sentence, that would give us an opportunity to work with them. So on the rehabilitation side, these really short ones I just don't think they're worth the bang for the buck, right? You could stay in, like there are many local jails that have treatment services in them. So you could probably do more in a shorter sentence at the local level, and get some treatment or some type of intervention than you could if you came to prison. But we also talked about the fact that that's not true everywhere either. Like there's disparity in what is available, whether they're out in the community or whether they're serving the jail sentence locally. So that, like, you know, the question that we came down to that we want to know is like, what is the actual purpose of the mandatory minimum? And one of the things that Ashley brought up is, you know, oftentimes what victims are looking for is, you know, maybe just stop the violence, right? Like stop the violence. And the real question there is then, what is effective to stop the violence? And I don't think that either of us were convinced that it's always this mandatory minimum that's effective at doing that. So like, how do we get to that root question of what's really effective there? And how do we diagnose, you know, where is a better use of our time and resources to sort of change that trajectory? But there's, and I will say, now I'm sorry, I mean, I know I'm talking too much, but like on the rehabilitation front, there's a real difference for me between felon in possession and commission of a crime with a dangerous weapon. We also asked the question of like, what are those predicate offenses that caused a person to be a felon in possession? Because we might feel differently about the response if it was a prior domestic violence versus a prior drug possession. That might be a different situation that calling for a different response. So that's something we wanted to know more about, is what were those predicate offenses. And then for treatment, on the treatment front, I'm sitting here going, if the crime is felon in possession, then it's a little harder for us to diagnose what we can do to intervene in that behavior on the corrections side. I mean, we do a lot of assessments, and there might be some other thing going on, just antisocial personality, maybe it's a drug use problem, whatever. Maybe there's something we can identify to address, but it could also be environmental, that they live in a community where people feel like they need guns to be safe, and we can't fix that through treatment. So there's some cultural and environmental issues that are kind of out of our control as well.
Can I ask a question, maybe more of a comment too, is I think along with that is the provision about no early release. On a lot of those offenses in subdivision 9, you wouldn't be eligible for a challenge incarceration program anyway.
Right.
But felon in possession falls under that. I know some people have still gotten into the program, but it does sort of gum up the phase 2 and phase 3 in the community part, because they're normally then kept on for far longer than someone else. And then it's sort of, how do we treat this? And I think especially though, some of those people, and depending on the crime they can't possess for, would be much better suited for CIP and have it be cleaner if that sort of provision wasn't there either.
Correct. Yes.
Just great discussion. I had sort of meant to talk about rehabilitation within the context of recidivism, but I think you absolutely captured that, a really good analysis there. And that was the same conclusion that I came to, which is I have not found much support for this idea that putting people in prison on these mandatory minimums decreases recidivism. And I think a lot of the reasons that you explained are correct there. And I keep on coming back to this idea that, these folks are going to come back into community, right? I mean, these are sentences of 3 to 5 years. And so these people are going to return to community. And so, what is the best outcome that will reduce the likelihood of future crimes? And then the last sort of like public safety indicator is this idea of incapacitation. And so that's the one area where I do feel like, obviously, sending people to prison takes them out of community, right? And so that makes it less likely that they're going to be able to commit crimes in the short term. So there's just a reality of that. And so in that regard, I think if the point of mandatory minimums is to incapacitate people who have guns, it is accomplishing that in the short term. But because of those issues that you just talked about with recidivism, I do wonder in the long term, is incapacitation a goal here that we want to, that is accomplishing our long-term goals. And then finally, the last thing was just, and I think this might get into the next category. And so, Mark, if your legal analysis group is going to talk about this idea within the guise of fairness and proportionality, I did want to highlight public trust in the judicial system here. I do think that some people look at the mandatory minimums as pretty harsh, and I think that sometimes they can undermine public trust in the system. I've certainly seen cases where families have concerns about a loved one, but don't actually contact law enforcement because they're really concerned about what might happen to that person. And so I do think in some regard, mandatory minimums can undermine public trust in that they're just a one-size-fits-all solution. There's no judicial discretion involved. But I can, if the legal analysis folks are talking about that idea too, we don't have to talk about that here. So. Okay, any other discussions on public safety?
I just real briefly, based on what the data subcommittee talked about, I just wanted to mention just a couple of things that we talked about. I think mostly what other people have mentioned is a lot of what we kind of covered. And so, one of the things that I think, and I think Kelly kind of maybe touched on this a little bit, was whether there's a conceptual distinction between situations in which a person is, let's say, they're convicted of a crime of violence, and then at a later time in their life, at some point, they're like, say, pulled over, for whatever reason, law enforcement searches their vehicle and they find a gun, right? And that being kind of one type of situation compared to, say, another type of situation in which they had been previously convicted of a crime of violence, and then they have a new kind of crime of violence they're engaging in and a gun, right? So they have the new crime of violence plus the, possession of a firearm after a crime of violence, and whether there's a distinction between, one that's a bit more, or clearly more proactive, potentially, versus one that's maybe less so. And, one way to think about that, obviously that has, maybe there's different intentions and whatnot, and I don't know how you would ever actually get at like kind of understanding people's intentions on why they have a gun in a meaningful way. But as, a bit of a proxy to kind of understand those two things. And then of course there's a difference in potential outcomes and where, the second group where they have another crime of violence case as along with the possession of a firearm when they're prohibited. The role in which that plays in like a plea deal leverage, because you have this mandatory minimum 5 years as well as this new crime of violence. And so how does that play out? And that might be more murky. But we were kind of thinking, well, maybe it would be worthwhile to think about what an analysis would look like in which we kind of look at those people that just have that violation of possession of a firearm while prohibited. And then doing some kind of just demographic comparisons, looking at the people, breaking it down by the different statutes for which the crime of violence subdivision, all the statutes that includes, or the different crimes that includes, breaking that down by demographics, and then looking at the second group, which would be looking at the people for who are then subject to these later, possession of a firearm while prohibited. And then kind of comparing those outcomes, and then thinking about some other contextual factors such as, who has guns, like who legally possesses guns, the types of guns, why they have guns, thinking about some survey data or something that we could pull in that exists, not something that we can collect ourselves, but something that we could look at. And I mean, are we talking about hunting? Are we talking about protection? Are we talking about, whatever? Just to get a kind of context of what's going on.
Mark?
Yeah, I just wanted to follow up on one thing because I didn't discuss incapacitation, but one thing that this plays into, and you can see this as value in the mandatory minimum or not, but with the research showing that people age out of crime, for youthful offenders who have had 2 priors by age 19, that mandatory minimum does create a sentence that incapacitates the person significantly towards when we assume they're going to age out of violent crime.
Although the flip side, I guess, is the lifetime look back on crimes of violence. If I commit a crime of violence when I'm young and then when I'm old and perhaps not prone to crime anymore, I'm hunting or something like that. There's just not really a public safety implication there. So, I mean, it is an odd feature of the firearm prohibition that it is a lifetime look back. That's a very long time.
Yeah, I'm just talking about the physical incapacitation created by this particular mandatory minimum.
Yeah.
That
No, I
the
was
person's
just
going to be
picking up on
in
that
prison
concept.
during, if someone is particularly prone to crime between ages 19 and 22, and they've committed 2 violent crimes before age 19, incapacitating them for 3 years is in the interest of public safety.
So I just want to point out a little math fact, and that is that we pretty much have about 3 minutes per square if you divide the 28 squares by 2-hour meetings. So, but I do recognize that public safety is kind of the big daddy evaluation criterion. So it does make sense to spend more time on that, but we do need to be wary of using this much time. I love this discussion. I feel like this could be on, NPR midday. I'd listen to it. It's really interesting. But so carry on, but quickly, please.
Well, yeah, I think unless other folks have stuff to add here, I think I turn it over to the legal purpose and analysis folks to talk about fairness and proportionality.
Yeah, on that, there was a couple things. I mean, one is that, recognizing that there is some measure of proportionality already built into the system, particularly in that, repeat offenders are going to get the greater enhancement, is one way that proportionality is built into it already. And also that lesser crimes aren't included in subdivision 9, that reflects proportionality. However, it was also pointed out by a member of the committee that there's at least 4 issues that go to this that show the problems in this area with these particular mandatories. And one is that the failure to distinguish between possession and use of the firearm. Obviously having it in the console of your car is very different than pointing it at somebody. A second is that it doesn't account for differences in the crimes in subdivision 9, that as both murder 1 and simple robbery treated the same. A third is that guns and ammo are treated the same way. And a fourth is that it tends to flatten the results for people with very different criminal history scores. And so it's cutting against reflecting proportionality in that way.
Mark, I just make a technical observation on your third point. I'm sorry, the second point. So I think with respect to this column where we're talking about felon in possession, it's not subdivision 9 that it's implicated, but it is. But it's a good point because rather than subdivision 9 for purposes of this one, I think that's a good point for the third column. But
yeah,
for purposes of this one, what's not accounted for is what the underlying so-called crime of violence was. And obviously the least violent crime of violence is 5th degree possession of a controlled substance, which is still on the list, right?
Yeah.
So if your prior crime was you were convicted of 5th degree possession of a controlled substance, you've committed a crime of violence and you have a lifetime ban with a 5-year mandatory minimum if you ever possess a bullet for the rest of your life. So I think that's a great proportionality observation. But the subdivision 9 then would go in the third column. Thank you.
Yeah, and there's more, and in fact that's where that comment was made by the member of the subcommittee. I just lopped it into the wrong place. One thing too with fairness and proportionality is that related to the way in which say second degree murder, well, if someone's being sentenced for second degree murder, it's highly unlikely that the mandatory minimum is going to be what's driving that sentence. So there's no additional cost for the use of the weapon. Now, of course, if you committed second degree murder, almost always it's going to, be with a firearm or another dangerous weapon. But that we lose the fairness and proportionality in those upper level crimes. And we see it, there's another part of when we look at the guidelines, we've got an area where something like that is done for the higher level of crimes within assault, because a 5th degree assault is going to be elevated to a 4th degree because of bias motivation. But then for the higher levels of assault, it's a plus 25% to the grid. And that's what's not done here. So.
Was that all you had for row B?
Yes.
Okay, great. We'll pass it along then. And any questions that you had, or I guess anybody else have any discussion on fairness and proportionality with respect to either of these 2 mandatory minimums?
Yeah, I just had one. I just had one that I was going to dovetail with something that Mark just said about it cutting against the sentencing guidelines. If you look at the data that we had collected, there's almost a perfect inverse relationship between criminal history score and departure rate on these.
Right.
And so what you're is for the ones that aren't the mandatory, clearly the bench is trying very hard to correct this at the lower criminal history scores and is not interfering with it very much at all at the higher criminal history scores.
Yeah, I think that's such an interesting observation. Anything else on row B?
I have something on where it was listed with the 4 issues. The first one is I have concerns on where the discussion is about, especially for felony possession by person ineligible. It's not about how they use the firearm. That's a separate crime. So by throwing that discussion over how they use it, we're imposing and changing the nature of the offense charge. The offense is basically a person who's committed some prior act we've deemed as a society inappropriate to possess a gun. That's the crime. There's certain people who are just not supposed to have guns, period. It doesn't matter how they're used. So by focusing attention on how they use it, you're adding a different crime they're doing, but also ignoring the fact that they've had the gun. That's the crime being punished. And I know in my jurisdiction, I've used it when we've had rival gangs or factions fighting off against each other because they won't testify against each other on the crime committed. So it's been a good public safety tool to enforce just the fact that they had a gun. So that's something I worry about when we discuss this particular crime versus the second group where you're using a firearm or dangerous weapon. So I think the focus more should be on what are those lists of subdivision 9 crimes. You know, the easy one, and I can see a lot of logic in that, is 5th degree drug possession. Is someone who has that history the person we should be concerned about versus the higher level? Because even domestic violence felony isn't listed, and that person's more concerning to public safety.
Yeah, and just for purposes of note taking, I want to make sure we're clear on what we're talking about here. So the felon in possession crime has nothing to do with subdivision 9. It has to do with this list of so-called crimes of violence. It's a very long list. It's found in 624.712, I think subdivision 5. And at the end of it, it says, and any felony violation of chapter 152, which includes 5th degree drug possession. But it is a long list, and I think most people would look at that list and say, yeah, those are violent crimes for the most part. But I think a lot of people would get off the bus at certainly, 5th degree drug possession, as I said. Not that there aren't violent forms, not that there aren't violent crimes under chapter 152, but I just don't think, I think just most people would agree it's overbroad. So that's not the subdivision 9 list. The subdivision 9 list is then in the 3rd and 4th columns where you're committing a crime. So you are actually committing a new crime, not just merely possessing a firearm or ammunition. And then, and I think both are valid, right? I mean, so what is the subdivision 9 crime? It might be murder, and what's the point of adding a 3-year or 5-year mandatory minimum to murder? It doesn't do a whole lot. Anyway, and I'm not trying to undercut your point, Shane. I think it is an interesting point, but I just want to make it clear. When we're talking about felon in possession, we're not talking about subdivision 9. We're instead talking about a different list, which is the list of crimes of violence in chapter 624.
It's still the same principle being,
right.
You've committed a group of named offenses, now you possess a gun.
Exactly.
We muddy the waters by talking about how they use the gun. Instead of focusing on issues of, are the crimes on the list the ones we should be saying you shouldn't have a gun for life? Focusing on whether the length of time, whether life is too long. I've had a case where the guy was 1989 conviction for 5th degree drugs. That seems to present a problem. So if by focusing on how they use the gun, we lose track of the fairness and proportionality issues on what this crime actually is punishing.
And just for note-taking purposes, this is a first column point, not a third column point, just to let you know. All right, but again, Shane, not to take away from your point, I'm just trying to keep Wilder on track.
No,
I think that raises, like, I think Shane just articulated a question in the what do we need to know column, which is what are those prior crimes of violence that resulted in felon in possession charges, right? And is there, and then it sort of adding in Dale's point, like, is there a difference in the departure rates for those based on what that prior offense is?
And interestingly enough, a part of our meeting materials today is a fiscal note that in part answers that question that we were going to get to later in the agenda if we have time. All right. Anything else on fairness and proportionality? And again, I'm really really excited about this discussion. I think we're bringing up a lot of really good points. Dr. Stewart, you want to take us away on equity and disparities?
Sure, and I'm just going to follow everybody's path and go way over the 3 minutes. No, I'll just be brief. I mean, I think the like I said, I think, and Kelly actually just kind of mentioned, I think one of the things is kind of understanding, for this one in particular, how does subdivision 5 or the crimes of violence subdivision, when you break that down by individual crimes, how, like, what are the demographics? What's the geography? Where are these things happening and who is it? And then how does that compare to the people that are later facing these possession of firearms after a crime of violence, to kind of understand, because there was a point, someone brought up a point that said, basically, like, if you're in Minneapolis, you have a higher likelihood of running into law enforcement than if you live in, a rural place with fewer, where people are spread apart and there's fewer law enforcement and whatnot. But that's where, I think some of the stuff about, like, the intentionality comes in. But, I think to Shane's point, I mean, it's still a crime, right? So that's kind of what it is. And so, I mean, that's kind of mostly what we talked about, just kind of understanding the context of, how and why people possess guns and whatnot. And then I also think the relationship potentially to, I think some of the analyses that we talked about in the public safety piece kind of speak to this as well. Understanding, like, how, whether there's an incapacitation effect and whether that is, a meaningful incapacitation effect relative to, and I think there's ways to get at that. So, yeah, I mean, a lot of what we've already talked about addresses this. So that was under 3 minutes.
You got 4 squares, so that was way under 12 minutes. But so I mean, you raised a lot of questions. Any any answers that you have on equity and disparities? I mean, is there anything you already know about equity and disparities that would answer these questions with respect to these 2 mandatory minimums, a felon in possession and committing a new crime with a dangerous weapon?
So we had identified, Morgan actually had identified a couple of different reports. I think some that were put together already by the Sentencing Guidelines Commission. I think one of them was maybe for, like, a potential policy change or something, so it was like something that, put together for the legislature. And so I was going to look into some of these data and then kind of assemble this stuff, at a later time. The other thing that we were thinking about was the permit to carry element of it, as a way of understanding, like, who owns guns and, legally and whatnot, and why, and whether or not, Amber had brought up a point about, if someone has a stay of imposition in which that person, and this is a little off topic, but stay of imposition in which, the person successfully completes, and so it's reduced down to a misdemeanor, whether that becomes a barrier to a permit to carry at a later point. But I see Shane shaking his head yes.
It's a crime of violence. It's treated as a disqualifying conviction regardless of state of or success.
Okay.
Supreme Court.
And so, yeah, I mean, I think, I don't know, anybody else in the committee, anything I missed that we talked about in relation to this? To be honest, we didn't do a really good job of distinguishing between these two, between the possession of a firearm after a crime of violence and possessing a firearm while committing a crime, or possessing a dangerous weapon while committing a crime. So we kind of talked about this in a more global sense.
Yeah, that seems to be kind of a theme, but it's okay. That's okay. This is all very good. Any other comments from the task force on equity and disparities?
Oh, sorry, one more thing about the chapter 152 and determining that role, the role of chapter 152 generally, and I think somebody else had mentioned this earlier, but really kind of understand, I mean, is the bulk of this being driven by chapter 152 in terms of these future crimes of violence? I mean, the future possession of guns or not, and within 152, how does that break down? Because the vast majority of 152 crimes are 5th degree possessions. So just kind of.
Yeah, and we do answer that in our fiscal note to some degree, which is going to be in your meeting materials. Okay, and actually I completely spaced it out, but we also did a demographic impact statement on Senate File 667. So we do have some demographic analysis of that. Maybe that's what Morgan had found, but I didn't include that in the meeting materials. So I apologize for that. I can put a link out there, but basically it kind of answers the question, sort of a what if question. What if chapter 152 was removed from the list? What would happen then? And that's basically what the fiscal note and the demographic impact statement answer.
So I would just kind of throw one quick point out on the 152, just because of how it's laid out. I know how law enforcement utilizes it, especially as we're doing narcotics investigations. Obviously, I think people are well enough aware, especially in the city of Minneapolis, the amount of shootings in relation to kind of known drug areas that are occurring and happening. Firearms are often related into ways to protect means of drug trafficking. Now, in Minnesota, right, for us to, find the evidence and get for sales versus possession, oftentimes, prosecutors will lean on just doing the possession charges versus the sales, because it's easier to prove when I do warrants or whatever, and I collect X amount of evidence in it that here, this is easy to say he possessed it. It's going to be more difficult for me to show sales.
Sure.
So I think something to keep in mind when we talk about 152 is there is an element of violence that exists in that. And when we're looking at how criminals are being held accountable, or people are being held accountable for those violations, especially if they're in the sales realm, oftentimes they are just getting possession charges, even though they are known sailors in the criminal event.
And I guess I would also add, though, that the way the legislature structured it is, if you possess enough, that it's basically the legislature kind of imputes sale culpability to certain levels of possession. It's like you wouldn't have that much unless you were selling. So they'll rank, a first degree possession of a larger amount of drugs equal to a first degree sale of a smaller amount of drugs, because they kind of think that person's probably selling anyway at that point. Okay, well, we should probably move on then to Assistant Commissioner Mitchell, if you'd lead us through impact on victims and survivors.
Okay, so we did try to differentiate between our little squares. So just, I'm a rule follower.
Thank
Probably
you.
why I work at the Department of Corrections, because we follow rules there. But so for felon in possession, that one was a little bit harder to pin down from the victim perspective. So we had more to say on the crime that the crime committed with a dangerous weapon. So for felon in possession, some of the things that we talked about are, you know, not all situations are the same. I think this goes back to the comment that was made earlier, that it could be just be somebody who pulled over and has a gun in the car versus someone who's actually now involved in a new offense that they also had a weapon at. So there's differences there. We were very interested in understanding what the preceding crime is, because we had much more concern about a person who committed a prior domestic violence and now was in possession of a firearm than a person who might have had a drug crime and was now in possession of a firearm. And I think that we were thinking in the possession type realm of drug crime, not the dealer kind of drug crime. So we really did see a distinction there and wanted to know more about you know, what those preceding crimes were. If we move over, we spent a little more time on the second set of offenses and committing a crime with a dangerous weapon. And this is where, you know, from the victim perspective, you know, we think that there are mixed responses to this question of, is this policy accomplishing its goals? You know, some victims do feel relief when a person is incarcerated. But the other side of the coin is that victims really just want the behavior to stop, right? So if it's a violent behavior, they want the violence to stop. That's what they really want. And so for some, so there's like both perspectives, safety from incarceration, but is this really going to stop the violence? When we got into the what more do we want to know column, you know, we really thought we do want some direct input from victims on these questions. So hopefully the stakeholder piece will get us some direct input. But we really, what Ashley talked about was thinking about the experience of the victim or the survivor. If they feel satisfied with the court process and that things were moved along fairly, then they might be okay with whatever result comes out of that. And the question that she had is does the mandatory minimum actually matter to that feeling of whether this was a just outcome or not? Like the court process itself might dictate that more than the actual, you know, imposition of a mandatory minimum crime. And so that's a question that we have that maybe we could get input from victims on. Anything you want to add, Ashley?
No, I don't. That was great. Thank you, Kelly.
What we got?
All right, any input from the larger task force on the impact on victims and survivors? All right, well, you're still on the hook for the next line, system functioning and feasibility.
Okay, so for this one, I'm going to start in the last two columns first because they're a little bit easier. The committing a new crime with a dangerous weapon. So here again, I came at this from the DOC perspective, and I mentioned this a little bit earlier, but like I really do think there's a difference in effectiveness depending on the length of the sentence. So if it's a very short sentence, then a prison sentence is probably not going to be effective for anything other than that short period of incapacitation. We're probably not going to have time to effectively intervene and do an intervention that could change that person's behavior long term. And so like when I look at the dangerous weapon offense or the dangerous weapon offense that's not a firearm, that's first time you do it, it's a year and a day. I don't see anything happen, anything positive coming from that prison sentence, because other than incarcerating that person for a year or whatever it ends up being after their credit for time served, we're probably not going to do much with them while they're at the DOC. For the little bit longer offenses or longer terms, then we'll have a chance. We'll have a chance to actually do that intervention. So then the question is, is prison the right place to do that, or would it be more effective to keep them in the community? Maybe they're doing some time in jail, or maybe they're getting into a program in supervision that would be more effective. So that's the DOC sort of perspective, but we talked about needing more input from the other actors in the system about their perspectives, because, for instance, for prosecution, a mandatory minimum might be a tool that is used to get to conviction, just as Shane Baker described on his gang, example, the example of gang members not wanting to testify against each other. So we would really like some input from the other actors in the system. Going back to the felon in possession one, here again, we struggle with this one at the DOC. If that's all they're coming in with, we might struggle to find an effective intervention for that individual. If they're not coming up on our assessments as having something else going on that we can do an intervention with. So if it's antisocial personality behavior, we're going to do cognitive behavioral therapy with them. If it's an SUD problem, we're gonna get them treatment for SUD issues. But if if none of those things are coming up and they're coming in for drug possession or a weapon possession, what is effective? It might be the environment that they're coming from that really is a bigger factor in why they had the gun that day than anything, any criminal thinking or anything that we could actually do something effectively to intervene. So this felt like a very blunt instrument for this offense. There's a lot less, I think, as Mark really described earlier, there's a lot of nuance here as to why they might have possessed the weapon that isn't captured in the offense, and that may not be, that 5 years is a long penalty for if we don't take all of those different factors into account. So, and then we didn't talk a lot about the victim perspective on this one. We talked more from the system functioning kind of perspective. So I don't know if there's anything else that you wanted to add there, Ashley. We didn't take any notes on the victim side of it.
No, I think that, I guess there's kind of the question of does having a mandatory minimum impact the victim's experience going through the criminal legal system? I guess I feel like this is kind of, and I think this maybe was brought up to a certain extent, does this impact the victim's experience, with pressing for a plea deal, if the prosecutor is pressing for a plea deal, or the defenses, or just kind of maybe some of those, that perspective I think would be helpful in kind of understanding how the system is functioning when there is a mandatory minimum in these cases.
So I agree a lot with what Shane said earlier. I think the ability to prosecute people who are not supposed to possess guns for possessing the guns is an important law enforcement tool. And we see this in a bunch of different aspects. I think the example Shane gave is a good one. And then I certainly see them in, someone's driving a stolen vehicle that was taken in a carjacking the day before, and like, we're pretty sure they did the carjacking, but there's a gun in the vehicle that they're not supposed to have. And so I think the ability to use that charge is really important. On the system functioning and feasibility question, I think from prosecutor's perspective in Hennepin, a large jurisdiction, and I hear this from some judges as well, that we do feel like the mandatory sentence that goes along with that charge can really handcuff us and limit our options. Because, you know, we're set up to consider the litany of factors, right? The circumstances under which the gun was recovered, what's going to be most effective intervention. Is it DOC? Is it local confinement, right? So we're set up to think about those issues in all of our other cases, but the mandatory minimum prevents us from thinking about it in this category of offenses. So I don't want to take away the ability to charge this, right? I think it's important that we have this in our toolbox to charge. I do think sometimes the mandatory sentence that goes along with it takes away the flexibility in the system. And on the victim front, I totally agree. We should get more input there. You know, I obviously have a lot of discussions with victims about resolutions in cases. And, you know, I totally agree with the analysis that Kelly and Ashley talked about. I think different victims think different ways about this. I do think sometimes the mandatory minimum sentence is a little confusing for victims, because a lot of the perception of the criminal justice system is judges get to decide the sentence, right? And so now we're in this world where actually judges don't get to decide this. And I think that sometimes makes the victim communication piece a little complicated. So.
Can I feel like this could be a can of worms. How do I say it? And please be honest with me. Is it ethical to do like charge stacking? Like, you can't prove someone did something, so you're gonna charge them with something else. And if it is, it's like, just like educate me. I'm just kind of curious. I really don't know. Like,
No, there are certainly ethical concerns, right, in any charge decision, right? But if someone's prohibited from possessing a gun and they're caught possessing a gun, that's a case that I can prove, and it's totally ethical to charge that. And then the context in which they possess that gun, I think, is a factor that I would consider in sentencing. So if they possess that gun in a stolen car that was taken in a robbery the day earlier, that's a factor that I would consider in thinking about how I want to sentence that case. You want to get?
Is it? I didn't know if you guys were
Rob?
on this call. So
Rob,
we
you
have,
had a question?
and Dale too.
I think Dale was in front of me.
Okay.
All right. I was just going to, when I think about system feasibility too, I look at what is happening in practice. And in this particular type of offense, the overall rate of departures is over 50%. And only if I'm reading the chart right from the data we got, only 20% of those were over the state's objection. So that tells me that the prosecutor and the bench are departing at a pretty high rate on this type of offense. And that to me tells me that the system is not functioning the way the mandatory minimum is intending it to do. So that either means the mandatory minimums are too harsh or the system is too weak. And I'm sure great minds can disagree on that. But for me anyway, the feasibility goes directly to what are we doing in practice? And in practice, there are a lot of departures on this type of offense.
I guess I would take a different point of view on that point. We're talking about the system's failing and there's a high rate. Well, this is easier on the felon in possession. If someone has a low criminal history score, the statute provides for an escape hatch, so it's waivable. That seems to indicate it is working, because the prosecutor, the judge, and defense are identifying those cases where this one size fits all is not the best outcome.
Well, I don't necessarily disagree with you on that, Shane, but to me, it's also, is that the way you want the system to function, or do you want it built into the sentencing guidelines? And it's not really a mandatory minimum if we're disregarding it half the time. And I don't know that you're getting, the way I understood the question is the system actually carrying out the intent of the statute? And I don't think that it probably is in this instance.
I'll just say as a former, I wouldn't say small county, but sort of mid-sized rural county or ex-urban county, I relied on sentencing guidelines and mandatory minimums for norm setting because I didn't have, I'm not like Hennepin County where we do these, we do carjackings every day, but so really, there's kind of a geographical disparity problem there because, you might have sort of your own informal guidelines in a major county in the metro, but in a smaller county, you have to rely on these statewide guidelines, and you assume that they're real. You don't know that there's a more than 50% departure rate. So I kind of am agreeing with Judge Harris on the idea that there's a problem if it's a high departure rate.
So just to kind of jump off a little bit of what Ashley had brought up, I guess my perspective on this is that, like, I don't think it's appropriate to be able to use unproven conduct as a tool, right? Like create a default in which we're using a mandatory minimum, to account for unproven conduct we can't prove otherwise, right? And I understand that that's not there's a reality of what happens on the ground, but I also think, like, in terms of the system that we have, like, I guess when we're creating a default in the way that we are with we're not creating, but there's a default in what we have, which is the mandatory minimum, and it is waivable. But I think to Nate's point, it's going to be waivable in some counties more than it's going to be waivable in others. And you're going to have court norms and whatnot. And I think defaulting to the harsher end of it, to me, is inappropriate because, whether it's a carjacking or whether it's rival gangs or whatever it might be, like, it doesn't seem appropriate because, to be able to, use that as kind of the default mechanism and then apply that to potentially other cases in which, it's just some guy that's got a gun in his car, which again is illegal, but it's not. But what I'm saying is it illegal to the point where we need to send somebody to prison for 5 years for that? And, I don't know how we would meaningfully be able to distinguish, at least at an aggregate level, these different things. But that's where I think, from my perspective, the default should be the minimal charge, but within the option then to, to say, hey, I want to request this additional thing because, whether it's an aggregate or whether it's, some type of, thing you add on top, through a guidelines mechanism, that then allows the judge, to take that into account and add it when appropriate. Otherwise, you're going to get situations where, judges who maybe don't deal with this a lot are just going to go with the guideline because that's go with the mandatory because that's the mandatory. So I don't know. I guess that's the way that I think about it.
Yeah, those are all great points. Really good discussion on both sides.
Jeremiah has his hand up.
Oh, thank you. I don't know why I can't see those. Jeremiah.
No, I'll just kind of make it real quick in there just to kind of clarify some of the points, I guess. When we talk about, and I think the term was used, kind of charge stacking or, oh, we can't prove this, so we'll get them over here type mindset. I think what we have to realize is that what we're talking about is that in the course of some investigation, we might be investigating a second-degree assault or a carjacking or whatever, and we go and locate a potential suspect in that case. We might arrest them, they have a firearm on them. So we're not like finding these, oh, we got him, we couldn't get him here, we're gonna get him over there. Like, it's still evidence of a crime. And in reality, if the attorney has good faith that they're going to be able to prove all the crimes that this person that is under suspicion of, they'll charge all of those crimes. What I think was kind of talked about is sometimes these individuals will get involved in these other greater violent crimes, and all the attorneys are left with is the case I can prove is going to be the possession of the firearm. So it has nothing to do with like kind of like, oh, we got him over here versus that. So I just think we got to like know that is, I think, the intent with that. The other thing is the language that we use. I think when we start saying, oh, it's just this guy rolling around with a car, and that we're starting to minimize the criminality or the mens rea of this person who has already been convicted of, and we're talking crimes of violence. So we're talking about murders, weapons crimes, criminal sexual assaults, very violent individual crimes that they've been convicted of that put them in a position to where they shouldn't have firearms. Where we as society, I do believe, feel people that are convicted of those crimes definitely should not be running around with firearms. I agree with that. If they have this propensity to violence, they're showing that they have already been convicted of crimes of violence. So it isn't about somebody who like, oh, hey, I'm just driving around and here it is, I have a gun. They really have some significant violent crime and tendencies that they've already shown. Again, we can have a conversation about, well, that was 40 years ago or that was 20 years ago and there's been nothing since. I think I can agree with some of that stuff where, yeah, I really messed up and here's what it is. But sometimes we do make decisions in life that have life consequences, and they are going to prohibit us in things we do in life. So I think like some of that stuff we just need to make sure that we're paying attention to as we're talking about like all of these mandatory minimums and things.
I would also suggest if you were to ask the average Minnesotan whether they think possessing, a quarter gram of cocaine is a crime of violence, I think they would probably push back on that.
For sure.
Which is why I think it's useful to understand how this breaks apart, right? Like how this breaks down in terms of the different, like these crimes of violence, how does that break down in terms of the private or the previous offenses? Because it could be the case, like you're saying, that these are like more serious things, but I think, the modal offense for a drug crime is a 5th degree possession, right? And a modal offense actually for, I think, almost all felonies is probably a 5th degree possession. So, 3rd degree burglary and 5th degree possession are kind of two of the higher ones. And so, what I'm trying to point out is, what I'm trying to suggest is that there is a significant net widening I would expect a significant net widening effect, specifically because of Chapter 152, right? And I'm not exactly even talking about 1st degree, 2nd degree. I'm talking about 5th degree, but I take your point.
I mean, and to make the case even more extreme, it could have been an adjudication for delinquency in 1985 for possession of a quarter gram of cocaine, and that's all it takes. And if I possess a bullet in 2026, I'm going to prison for 5 years according to the law. I mean, that is the law. Okay.
Yeah, and that's I can say like I'll say some of that where we can agree, and I think that's what I was just trying to shift that focus in. If we're really looking at where we can make some maybe really good changes within this, is kind of where that sort of stuff is hiding out at, right, where it's sitting there. So if it's these a low level 152, right, a 5th degree, somebody who is a user amount, that sort of stuff, for sure. And maybe that's what we can start looking at with making some of those changes. But I just globally, as we're talking about it, I want to keep in mind that the offense we're talking about is one of a very small, when we have a lot more larger offenses. So if I'm good with positioning that, that's what I'm saying. As we talk about this stuff, I think it's really important to address what it is our concerns are.
Sure. Okay. Great discussion on the system workability. Let's move on back to you, Dr. Stewart, on data. I'm sorry, on fiscal and resource impact.
Yeah, so we kind of talked about, I mean, you know, I think the basic idea here is trying to understand, I mean, just like it says in the, you know, kind of the EG there, in terms of the examples, you know, trying to understand how, you know, what is the impact on the system in terms of bad counts and whatnot. I think this is something obviously that the guidelines is really good at doing, or the guidelines commission is really good at doing. You know, and I think this is where I think the problem I think that we foresaw is this is where it gets really murky, because especially when we're talking about the possession of a firearm after a crime of violence, if that's also associated with some other current offense, like a current offense happening, it's going to be hard to kind of distinguish, like, you know, the role of that in the negotiations, right? And so whether or not that's used as kind of, you know, because obviously if there's a 5-year mandatory for like and then the other crime maybe is like a carjacking or something, which is the lower level, then, you know, how is that dealt with? So we wanted to think about how to potentially estimate the kind of the overall cost of some of this, maybe by just looking at the ones that are the, you know, in which it is just the possession of the firearm on its own, so at least we can kind of separate it from other potential offenses. And then also considering not just the effect on like the resources that includes like the courts and the counties and the law enforcement and corrections department, but also you know, someone had brought up thinking about how does this also affect the families. Like often defendants will, or defense attorneys, I think will stand up and say, you know, if you put this person in prison, like they're not going to be able to support their families and whatnot. And you know, I mean, how much is that a tactic versus, you know, reality? I don't know. But I think thinking about that, you know, from a kind of a comprehensive perspective, thinking about, for example, whether or not, like if we can include, for example, uptake of community of like Medicaid or Minnesota Care or whatever it's called, you know, before and after. It's a little in the weeds, and I don't know how realistic it would be to do. But I think this is something where the Guidelines Commission would obviously be really well suited to kind of look into, since they do this a lot.
Yeah, so on this one, on the fiscal and resource impacts, I was the one that brought up what impact does this have on society? Because I think this question is phrased about what is the fiscal impact on our systems, jail populations, court workloads and stuff. But I do think the related question of what is the impact of these policies on our community is really important. And so I don't know if other folks have sort of thoughts on that. But I do know they're right, like certainly in negotiating these cases, you know, it's been pointed out to me that, you know, sending someone to prison for 5 years is going to have a really significant impact on that person's family and the impact that this will have on their community. So I've heard that argument. I've also heard a lot of discussion about like, okay, you know, you send this guy to prison, he loses his job, he loses his housing, and now when he gets out in 5 years, it's going to have a huge impact on his future ability. So I don't know how we measure that or how we capture that, but I do think it makes sense to broaden out when we're talking about the fiscal and resource impact of these policies. Can we look at what impact does that have on communities?
Judge Harris. Yeah.
I was just going to throw one thing in the second column for what else do we need to know, and this is much more narrow. But I would be interested to know whether cases with mandatory minimums, particularly the mandatory minimums, result in more jury trials, because that is something that does have an impact on the system. I don't think from a prosecutor's standpoint they're terribly hard to prove, but if you're the defendant and you know the judge can't depart, so there's no real sentencing argument to make. You know, when you got nothing to lose. Maybe you get lucky and you hang a jury or something. So I would be, in terms of the impact on the system, I would be curious if that results in more jury trials.
Conversely, it might give the prosecutor a lot of leverage and result in a lot of cases pleading out. It might result in fewer jury trials. So that might be
Oh,
a
yeah, I'll
system
just-
impact for reversing it.
I'll just say in Hennepin, you know, like, we do not try many of these. They're very easy cases to try, you know, they're pretty straightforward. They're not whodunits usually, so.
But even if that's the case, that's still like a full day, right? Like you're pulling that process, like you're taking
Oh,
a
yeah.
day's work of.
It's 2 or 3 days, picking a jury, you know, doing everything you have to do, and there's certainly been, you know, there's, some of these are more challenging than others, but yeah, when you look at the types of cases in Hennepin anyway, that are going to trial right now, it's not a lot of these. And the other aspect too is a lot of these folks, are probably in custody during the pendency of it, and so there's a motivation to negotiate a resolution and move on, but yeah, super interesting question. I certainly have data on that in Hennepin that we could look at, and I bet there's a way to get statewide data too.
Yeah, and maybe it's getting a little in the weeds, but that question reminds me of something that might fit under E, which is you know, sort of that the pickle you're in if it's a hard mandatory. It's difficult to plead guilty with any kind of a deal because it'll get reversed on appeal. I mean, there's sort of the you know the process those hard mandatories present some interesting challenges because on one hand, if the judge sentences below the hard mandatory, the prosecutor gets an automatic win. On the other hand, if the judge gives the hard mandatory, and the defendant was in any way told that, you know, the judge doesn't have to give them hard mandatory, then the defendant gets an automatic win on appeal. So it's and gets a second chance. So it's those hard mandatories do create an interesting appellate environment, and I don't know, that might be too involved to get into in on our report, but all right. So if there aren't any other comments on line F, then we'll go to back to Professor Osler to lead us through unintended consequences and risk.
Yeah, and I'm going to be pretty brief, and I'll try to distinguish better between the two categories this time. But just on the possession, I think, you know, something that Judge Harris just mentioned, that if we're getting over 50% departures on that, and there's definitely the unintended consequences of disparities in the way those departures are distributed. That, you know, where it is that you're being charged could be a factor. Also relating to that, one thing that potentially is problematic, and it's interesting because this is based on what Morgan said, you know, where you've got the gun in the car, it's there's not really a danger of coercive plea if there's one guy in the car. But if there's 4 people in the car and you want to tag one of them with the gun under constructive possession, then we're moving more towards that kind of a danger of potentially coercive plea, because there's you know, it's less of a sure thing that you're going to be able to prove it up at trial. And yet the difference, you know, in terms of the potential sentence is a big hammer to hold over somebody. On the possession or use in a crime, one thing that came up that overlaps with some of the other categories that I don't think was intended is that it encompasses crimes for which the use of a weapon is already an element. You know, for example, you know, a second degree assault is, you know, it's already baked in there that a weapon is used, and yet it's going to be listed. And also, you know, one of the things is that because of the addition of subdivision 5B, you know, a lot of times it's going to be easier just to charge the possession as opposed to possession or use in connection with the crime. And so we're not really reflecting the truth of the severity of the issue.
That's an interesting point. Any other additions from the task force on unintended consequence and risk to these two mandatory minimums?
So I just want to make sure we say it out loud that the disparities can be an unintended consequence. So like sort of going back to that tie that we've made where 5th degree possession is like the most, or 5th degree drug crime is the most frequently convicted felony, right? That triggers the felon in possession crime, and there's already racial disparity in who gets convicted of 5th degree crimes. So you are injecting sort of racial disparity in how these play out as well, just by virtue of all those other factors that lead to disparities in sentencing to begin with.
Mhm. Well, any other comments? I just want to thank all of the committee chairs for cooperating with my my request on the in January to pre-think this. I really think it made the meeting go much better. Ashley, I want to say I really appreciate your. I know ChatGPT helped, but I appreciate the structure that you gave us for this. I think it was immensely helpful to have that structure, and I think it passed its first road test. It worked pretty well, so I appreciate that. I'm going to move ahead then to, and I'm looking forward to Wilder sort of putting all this together in a way that makes sense. But I think there's just a heck of a lot of really interesting ideas that were generated by this group, and I thought it was I thought it was an interesting discussion. I'm going to talk a little bit about the. So this is a fiscal note that we did. When was it? I should know the date, but looks like during the 2025 legislative session. And this was a bill, interestingly, a bipartisan bill. The Senate author was a Democrat and the House author was a Republican. And it was, the bill was pretty simple. It was just removing I think it's the last line. It may not be the last line, but if you look at the list of crimes of violence, as has been pointed out, most of those crimes are pretty clearly violent crimes. But it ends with and any felony violation of Chapter 152, and the bill was simply going to cross that line out. So it was going to remove Chapter 152 crimes from there, which some people might argue is overbroad. You know, there are some. You know, and there's certainly been, certainly an argument to be made that, you know, there are a level of drug crimes where violence is almost inherent. And whether you respect that argument or not, there are some drug crimes, particularly under aggravated first degree controlled substance crimes, where there is a level of violence that's a little more explicit. At least firearms are used in the commission of the crime and so forth. So I think it is possible to get, or perhaps a little more nuance on this bill, where you do limit the Chapter 152 offenses to just the literally violent Chapter 152 offenses. But again, I have heard people make the argument, and I've heard it today, that there's just sort of this inherent violence that's associated with drug offenses. I'm not sure I'm going to adhere to that argument, but I do respect it. So anyway, this bill was just very simply going to take out all Chapter 152 offenses from there. And so what we did is we read through. So we took. So first of all, we're looking at cases. Our data set, the Minnesota Sentencing Guidelines data set, is looking at cases where the offense in question was the most serious offense sentenced for that defendant in that month. So these are defendants for whom the felon in possession offense was the most serious offense that they were sentenced for in a given month. And among those cases, so we found 2,731 such sentences within a was it a 5-year period? Yeah, well, 2019 to 2023. So yeah, 5-year period. And we took a 6.7% sample. So we looked through 182 criminal complaints to find out what was the prior crime of violence, because that's something that really should be alleged in the criminal complaint. And we found that in 29% of the cases in our sample, the prior crime of violence was, and I, you know, if they had multiple crimes of violence, it had to be the only prior crime of violence had to be a Chapter 152 crime of violence. So that's kind of an answer to a question that was raised here: is how many of these cases and was the prior crime of violence? You know, that last line. And again, you read through the list, and you know, most people, you know, if you were to do a man on the street interview, most people would say, yeah, that sounds like a violent crime to me. Most, I'm not necessarily going to say all, but the vast majority are pretty violent crimes. But 29% of people actually getting convicted were convicted for felon in possession based on a Chapter 152 crime of violence. And if you see that in Table 1, 64% of those, so 64% of the 29%, the prior crime of violence was a controlled substance crime in the 5th degree, and then lesser degrees. So the middle column breaks it down by the percent of Chapter 152s, and the right column breaks it down by the percentage of all the cases in the sample. So 19% of everybody in the sample was looking at being lifetime disqualification due to a 5th degree controlled substance crime. And those are just people convicted, right? I mean, it's quite possible that there are out there a large number of people who are subject to the lifetime ban, who are respecting the lifetime ban, who had the controlled substance crime in the 5th degree. Now, and then we looked at the prison sentences. So it's 29% of those cases, just looking at the amount of prison time that everybody got. These people were getting prison time for the felon in possession. The total prison time was attributable to the drug priors, right? So felon in possession due solely to a drug prior was 25%. So 25% of those prison beds were consumed by people who had the drug priors. Some of those people were also getting sentenced for other things at the same time. I told you that the felon in possession was the most serious crime, but they had other sentences for less serious crimes. So if you deduct out that prison time that they would have served anyway, and only 5 of the cases in the sample fall under this, where they were getting sentenced for other stuff. But that would be that brought it down to 22.5%. So not a small thing though. 22.5% of the prison bed impact for felon in possession went away under this bill, if this bill had passed, which ended up being an eventual 222 estimated prison beds. So that's a pretty big it's a pretty big number of prison beds. So that kind of gives you an idea, if you kind of reverse the math, of how many people are in prison due to felon in possession. It's a significant percentage, and 222 prison beds is not insignificant at all. That's over, you know, what, 5% of the total prison population would just go away if this bill were enacted. And as I said, we do have a demographic impact statement on our website. I did put a link to that in the chat, but I just spaced out including that in here. But it is an interesting demographic impact. It certainly would reduce the population. I can pop it up if you're interested. Let's see. I guess if I pop it up, we will have to include it in the meeting materials. I did put a link on the page, but in the chat, I should say. But here's the demographic impact statement sort of conclusion. And basically what this is showing. So we got the minus 222 prison beds here, and it shows sort of how that is distributed. Certainly it's going to affect males quite a bit. But you see here, we've got some, and this is, not something we're proud of in Minnesota, but we have very high rates of incarceration among, I would say, particularly Black and Hispanic, I'm sorry, Black and American Indian populations compared to the white population particularly. So the white population is 104 per 100,000. The Black population is 950 per 100,000, and the American Indian population is 1,100 per 100,000. That's actually, like, you don't have to say 100,000 at that point. You could just deal in terms of percentages. That's basically saying 1.1% of the American Indian population is in prison at any given time in Minnesota. So, and the demographic change here, if this bill were enacted, would be to reduce that number. That 950 number would go down by 19 per 100,000 in the Black population and by 52 per 100,000 in the American Indian population. Still would be above 1%, but it would be making some progress towards getting it down to 1%, which is, again, still very high, still 10 times the percentage of the white population, but one would argue making progress in that vein. So I hope that's helpful information, and I think it's relevant. Maybe we should have talked about that before, because it does bear on some of the discussions that we had, particularly regarding that. And that is an example of some research we can do. To Dr. Stewart's point, we do have a lot of capabilities with our staff, but we also are pretty busy, particularly during the legislative session, particularly with a bipartisan House, because there's no gate for what's a good idea, because both parties have good ideas. And so we ended up doing a record number of fiscal notes last year, and we're off to a rolling start this year. I don't know what it'll be like, but it does really consume a lot of, I should say, all of our research bandwidth. So I don't know that we'll have any excess bandwidth, but I can talk to my research supervisor about that.
Just real quickly to that point, I think we also have support from Robina, and they would, I think, be well suited to do some of that work as well.
Sure. Okay. So any questions about any of that information that MSGC provided on that bill? I hope that was somewhat helpful. Okay, so and now it's time for any subcommittee reports. I know we have a report from one subcommittee, so don't feel like if you're not that subcommittee, don't feel like you're on the spot to say anything. But I'll just go to the subcommittee. I'll start with the subcommittees that I know don't necessarily have, that I don't know have reports. So you're welcome to say nothing, and then we'll bring up Assistant Commissioner Mitchell to talk about hers. So Professor Osler, do you have anything?
No, nothing beyond what we already discussed previously.
Okay, thank you, and that was very helpful. And Dr. Stewart, do you have anything?
No.
Okay, sounds good. Assistant Commissioner Mitchell, please.
I do. So our subcommittee of two, and then Rob Stewart joined us because he was signed up to be on our subcommittee, but hasn't been able to attend because we've all been meeting at the same time. We worked on the RFP to get stakeholder input, And we had some really great proposals. We were able to choose someone to contract with to do that work. I can't say it out loud today because the contract isn't signed, but it is routing for signatures now. So we'll be able to talk about that more next time. But what I do want to talk about is the vendor that we chose would like to do what they call a consensus workshop, just to ensure that before they start the work of collecting the input, that they have clarity on what input would be useful from the task force. So they just want to do a little bit of work with some members of the task force to make sure that we're honing in on what those things are. The next meeting will be too late, like they need this month to do the work. So I wanted to throw that out there today and ask if there are members who would be interested in participating in that process. And I think that sub-quorum would be 5, right? So we can take up to 5 or, up to 5 total members from the task force to help us with that work. And that is, yeah.
And is that 5 in addition to you and Ashley or?
No, isn't the quorum 6?
I always defer to Don.
Quorum is 6, yes.
Quorum is 6, so 5 total.
Okay.
So
And how many people do you already have on that?
Well, I'm gonna assume that Ashley's with me. Yeah. So we have 2.
So we're looking for 3 more volunteers to help out with that workshop for our vendor, our stakeholder engagement vendor. Any volunteers? I see. So I can't see everybody. So
Rob just raised his hand, Rob Stewart. And I'm sorry, I should have said that it's 1 to 2 hours max. So that's all we're looking for is 1 to 2 hours from people.
I'd be willing to help out on that.
What's
Jeremiah.
that? Jeremiah?
okay. So we looking for 1 more volunteer by my count, which I'm not using a spreadsheet, so it might be wrong.
No, you're right.
All right. Well, I'd be happy to volunteer if it's
All right.
it fits in my schedule. So
That sounds good.
all right.
Thank you. So I'll be I'm hoping that we can't do any work on the contract before it's signed or we get in trouble. So I'm hoping that it will be signed by next week and that I will be able to schedule that date soon after that.
Splendid. All right. Sounds great. Next is Wilder revisiting the timeline and work plan.
Sure. Yeah, I was just gonna share that document that we've looked at a few times just to, I guess, get everyone excited that we are moving along. Let me see if I can share this. Yeah, so a few things will need to be changed because we know the contractor starting a little bit later than we had kind of estimated. So some of these boxes in the next time we share, if we have time at the upcoming meeting, will be rearranged, but we wanted to wait until everything was signed on that end. But yeah, so we're just moving along, and Nate, I think you alluded to it earlier. We'll plan on taking all those notes that Jennifer took, combining it with anything else. So if the committees have stuff that they want us to incorporate in or follow up with us, then we are going to start putting things together. And that will get us ready for the March meeting where we can start looking at anything else. I know we have, I'll stop sharing now, but the kind of next agendas would be looking at the additional areas. The other thing I just wanted to mention is that we reached out to the person who came to talk about open meeting laws, just to find out if we would be able to do an online whiteboard, something like a Miro board, for those of you who are familiar with it, that would allow us to continue to gather just some information. And I haven't heard back from them yet, but you know, that might be something else. That again, doesn't have necessarily anything to do with, there's not a placeholder in that timeline I just shared, but I just wanted to mention that I'm aware that sometimes we've been sending out things to work on between meetings. And if you get a request like that, the chair and vice chair want us to send something out and you do have any questions, you could always reach out to us to walk through anything. And I think that's all for the timeline, and then just another update about the next steps, unless the other Wilder team has anything else to add that I didn't include.
Yeah, so for between now and the next meeting, I'm gonna have a similar request to the chairs as I did this time, which is basically filling out that chart, but this time with respect to the remaining mandatory minimums. So the mandatory minimums pertaining to controlled substance crime, and then I guess above that in terms of frequency is the mandatory minimums pertaining to failure to register as a predatory, or failure to comply with registration requirements for predatory offenders. So I hope, and again, it'll be the same thing where if you want to do it the morning of, you're welcome to do it the morning of. But I really think this is a helpful process. I think it's helpful. I thought it was a helpful process today. And I think it's helpful to have people sort of pre-think it prior to the meeting. I think it makes the meeting go much better. And I again thought we had a pretty good product today. Got a lot of interesting points in there. I should say with respect to that, we did have some information in previous meeting materials, such as the report from the mandatory minimum or the predatory offender task force that you can refer to when you're going through those discussions in committee. All right, next would be public comment. Donna,
Hey,
do
can
we
I
have
ask
any?
a question real quick?
Yes, ma'am.
I'm just wondering if there's anything that we can do to help the data committee hone in on what they are doing, or like Rob, I felt last month that you were still looking for direction, and I just didn't know if you'd gotten it in the meantime, or if some of the discussions that came up today help focus some of the data analysis that you'll be doing, or is there anything that we could do to help you get better direction there?
I think based on the conversation that we had today, I think I have a pretty good sense of where people are and what they would like to see. And so I can work with, I'll probably working with Robina, identify some of these things, and then hopefully maybe we'll be able to have some stuff that we can share by the next meeting. But in the meantime, if there's any particular issues that people really want to know about, definitely feel free to reach out to me.
Great.
Thanks for that question. All right, Don, do we have any public comments?
We do not have anybody online or in the room.
Okay, great. And what is our next meeting date?
March 13th.
All right. Sounds good. And we'll, can we set up a, so that's a 10 o'clock meeting date again at meeting time. Can we set up a 9 o'clock optional space for committees to meet and discuss, go through the evaluation criteria again?
Absolutely. Just reach out to me if you want to have a committee meeting.
Okay.
And
all right.
For the data subcommittee, I thought that worked pretty well. So maybe we'll just pencil that in, and then if anybody has objections, please reach out. And Don, I'll send you an email.
Sounds good.
Terrific. Well, thank you all for your service on this task force. I think we're doing good work here, and I'm looking forward to our result. And looking forward to seeing you all on March 13th. We'll see you then. All right. Having reached the end of our agenda, there being no further business before the task force, this meeting is adjourned.